Your Lordship, subject to Your Lordship's convenience, may I make a mention in respect of item number 11 of part 2. This is a matter regarding the service of the petitioner who was ousted from service prematurely. And Your Lordship, I have asked the Learned Counsel for the respondent as to whether he will be able to be ready for tomorrow. He said if the Honorable Court is been ready to hear the matter.
I don't know whether there'll be time or not because we have other fixed matters also tomorrow.
For tomorrow.
And tomorrow is the last working day.
Yes. Yes.
So far as this
that's
court
why.
is concerned.
That's why. Yes.
So if the party agrees, we'll have a fixed date sometime next week.
Next week I may not be available. Next to next, Your Lordship.
Instead of the same being in the weekly list, you can have a particular date so that you
Yes.
can be ready for that day. When is it convenient? You are there on behalf of Mr. Bilaram Mega.
Yes, Your Lordship.
When? 12th.
12th.
12th of Thursday. 12th of
Yes.
February.
Yes. 12th of February.
Okay, as agreed to by the parties, that the matter be listed for hearing on 12th of February 2026.
God bless.
Take Your Lordship's indulgence in making a mention regarding item number 2 of the hearing list. Although it is fixed for today, my lord, my senior has some personal problems, so if this matter may come up after a week.
Who's for the other side?
I have taken the concern, Mr. Vandal Haka.
Okay. Mr. L.H. Dhyamshiva, Learned Senior Counsel, appearing for the respondent numbers 1 and 2. He said to have some personal difficulties to conduct the case today. On a claim made on his behalf and not objected to by the other side. Matter stands adjourned for a week.
And also, my lord, item number 3, same prayer.
List again after a week. Okay. Item number
3.
3 comes with 4. 3 and 4.
3 and 4 is my
They're
lord.
together.
Together, yes.
Who's for the other side?
Mr. Victor El Ralte, I have taken the consent.
Item number
Bilaram
3.
Nemi, what do you say?
No objection, my lord.
Similar order?
Yes, my lord.
After a week?
After a week.
Okay.
Obliged.
Orders item 9.
Where are the books?
You're going to get it from the.
I told you to keep it here in the courtroom. Why did you send it back?
No, I've kept it on the PS room.
Please write down. Please take your seat, both of you. I'll dictate the order. Heard Mr. Samuel Bangarsi Datsangte, Learned Additional Advocate General Mizoram, for the applicants, who submits that by filing this application under Section 5 of the Limitation Act, the applicants seek condonation of 406 days in filing the connected appeal against the order dated 29/2023, passed by the additional and district judge. I repeat, additional district and sessions judge, Champhai District, Champhai, in connection with LA case number 1 of 2015. Stop referring to the application and the statements made therein. The learned additional advocate general submits that the fact of the learned trial court, learned LA judge, having passed the order dated 29/2023, okay, you add judgment and order, okay? In the previous line also, judgment and order. Dated 29/2023, came to the knowledge of the applicants only on 6/6/2024. After a letter was sent by the counsel for the respondents to the Special Land Acquisition Officer, who in turn wrote to the project director, Project Implementation Unit, ISOL, on 6/6/2024. So by that time, eight months and 16 days time had already elapsed. Several attempts were made to obtain the certified copy of the judgment and order from the government advocate concerned at Champhai verbally. But however, as there was no reply, a letter for filing an appeal against the judgment and order was sent to the Joint Secretary to the Government of Mizoram Public Works Department on 7/8/2024 by the Engineer-in-Chief, Public Works Department. The Under Secretary to the Government of Mizoram Public Works Department, by letter dated 23/8/2024, wrote to the Advocate General for taking steps to file an appeal against the judgment and order. So although the said letter was received, but upon examination of the matter, it was found that a certified copy of the judgment and order, copy of the plaint submitted by the parties concerned, written statements and deposition of witnesses were not attached with the said communication. Stop accordingly, the project director, PIU, PWD, sent letter to the government advocate concerned at Champai on 2/9/2024, requesting him to send all the related documents in connection with the case, so as to enable the government counsels concerned to file an appeal before the High Court. So, however, as no reply was forthcoming, a reminder was sent on 22/10/2024 to the government advocate at Champai. So while such was the position, the applicants received a copy of the order dated 25/10/2024, passed by the Court of Additional District and Sessions Judge Champai in execution case number 8-10 of 2024, arising out of LA case numbers 1, 2, and 3 of 2015. Stop. As per the order dated 25/10/2024, in the execution case, a notice was issued to the present applicants to show cause as to why the prayer made in the execution application should not be allowed, should not be granted, while fixing 14/11/2024 for filing a show cause reply. To stop, the applicants, having not received any communication from their government advocate at Champai, sent Just read the sentence again. The applicants. Sent, you cancel sent. Requested the Law and Judicial Department by letter dated 6/11/2024 to look into the matter of the Under Secretary Law and Judicial Department by letter dated 30/10/2024 instructed the Government Advocate Champai to take necessary action and to provide all the necessary documents to the Office of the Project Director, PIU, PWD, ISO. Now, the Project Director also sent a communication to the Additional District and Session Judge Champai seeking adjournment of the execution case in view of the steps taken for filing appeal before the High Court. So consequently, on 5/11/2024, a copy of the certified copy, a certified copy of the judgment and order was issued and furnished to the council to prepare the appeal. And the said council started drafting the application for condonation of delay. Which took about 2 weeks' time. Stop. However, since the grounds for seeking condonation of delay were not sufficient, additional grounds with supporting documents were sought for. And thereafter, the council took 3 weeks' time to finalize the application for condonation of delay. And the appeal was ultimately filed on 30/1/2025. So the learned Additional Advocate General submits that by the time appeal could be filed along with condonation of delay application, there was already a delay of 406 days. And therefore, the instant application has been filed seeking its condonation. He submits that the delay is due to bona fide reasons and on account of belated receipt of the judgment and order of the LA judge by the applicants. He also submits that the applicants have a good case on merit and therefore the delay may be condoned. Otherwise, the applicants would suffer irreparable loss and hardship. In support of his submission, he relies upon the following authorities. Number 1. State of Nagaland versus Lipok Au and others, 2005, 3 SCC 752. Number 2, State of Rajasthan and another versus Bal Kishan Mathur, 2014, 1 SCC 592. Number 3, Shioraj Singh (deceased) through legal representatives and others versus Union of India and another, 2023, 10 SCC 531. Number 4, Improvement Trust This was by you. Okay. And you say number 4, okay? State of Uttar Pradesh and another versus Virendra Bahadur Katheria and others, 2024, 15 SCC 1. Next para. Mr. Alalbi Agnuvanhamte, Learned Counsel, appearing for the respondents, on the other hand, submits that the applicants were very much aware about the pendency of the land acquisition case, in view of the fact that they had not only filed a written objection, but had cross-examined the witnesses produced by the respondents. He also submits that on the date of pronouncement of the judgment, the government advocate representing the applicants was also present. Further, a copy of the judgment and order was also furnished to the applicants through their appointed counsel. And while the respondents were waiting for them to comply with the judgment and order, since no developments was forthcoming, the counsel for the respondents sent a letter to the Special Land Acquisition Officer, Public Works Department, forwarding a copy of the judgment and order dated 29/2023. Even then, despite receipt of the same, since no steps were taken immediately, the respondents had no other option but to file the execution case, seeking execution of the judgment and order of the LA judge. So he submits that no diligent effort was made by the applicants to obtain a certified copy of the judgment and order. Since they only resorted to writing letters time and again to the government advocate at Champai, who did not bother to respond. So he submits that even at the level of the applicants themselves, they have failed to show diligence by taking prompt steps despite receipt of the requisite materials for preparing an appeal. Stop. In this connection, he draws the attention of this court to the communication dated 7/8/2024 bracket annexure Roman 2 of the application close bracket written by the Engineer-in-Chief, Public Works Department to the Joint Secretary to the Government of Mizoram, Public Works Department. Stop. He submits that enclosed with the said letter was the grounds for preferring appeal along with other enclosures and including the impugn order dated 29/2023 sought to be challenged. So therefore, he submits that it is clear that as on 7/8/2024, the respondents clearly had the requisite materials to take prompt steps for filing an appeal. But instead, the appeal has only been filed on 30/1/2025. Which goes to show that the applicants have been grossly negligent to pursue the matter. At every stage. Stop. Such being the position, the learned counsel submits that the application seeking coronation of delay should be rejected and dismissed. Stop. In support of his submission, learned counsel relies upon the following authorities. Number one, order dated 1/7/2025, passed by coordinate bench of this court in IAC number 169 of 2024, open bracket, Silal Machuana versus State of Mizoram and others. Number two, W. Rabi Singh, B.I. Rabi Singh versus State of Manipur and others. 2012 3 GLR 482. Number three, Office of the Chief Postmaster General and others versus Living Media India Limited and another. 2012 3 SCC 563 and Pundlik, Pundlik, Pundlik Jalam Patil, bracket capital D, close bracket, by LRS versus Executive Engineer Jalgaon Medium Project and another. 2008-17 SCC 448. Next para. I have considered the submissions made by the counsels for the rival parties, and I have perused the materials available on record. To stop, according to the applicants, there is a delay of (406) days in filing the connected appeal, whereas according to the computation made by the registry, the delay is 407 days. As can be seen from the office note dated 30/1/2025. Full stop. Stop. The grievance of the applicants is in respect of the judgment and order dated 29/2023, passed by the Additional District and Sessions Judge Champai in LA case number 1 of 2015. Stop. According to them, the same came to their knowledge only on 6/6/2024, when the superintending engineer bracket PNW, PWD had forwarded the letter of the counsel for the respondents to the project director, Project Implementation Unit ISO, on 6/6/2024. Stop. Thereafter, the engineer-in-chief PWD wrote to the Joint Secretary to the Government of Mizoram, PWD, on 7/8/2024, stating that the Project Implementation Unit PWD is aggrieved by the judgment and order, and as such, an appeal should be preferred against the said judgment and order. Stop. What transpired between 6/6/2024 and 7/8/2024 has not been explained by the applicants, despite the fact that there is a gap of 2 months between the two dates. So the Under Secretary to the Government of Mizoram, PWD, then wrote a letter to the Advocate General on 23/8/2024 requesting the Advocate General to take necessary action for preferring an appeal against the judgment and order passed by the LA judge. So upon receipt of the said letter, the explanation tendered is that the documents forwarded were not complete, and therefore several communications were made to the government advocate at Champhai to furnish such documents, including the certified copy of the judgment and order, white letters dated 2/9/2024, 22/10/2024. And 30/10/2024, amongst others. Subsequently, upon receipt of the certified copy of the judgment and order on Five 11/2024, the counsel for the applicant started drafting the appeal as well as the application for condonation of delay. So, but then additional grounds were sought since the materials which were already furnished were found to be not sufficient. So thereafter, further 3 weeks' time was spent for finalization of the condonation application as well as the appeal. And ultimately, the appeal file along with the application for condonation of delay on 30/1/2025. So a perusal of the entire sequence of events goes to show that the applicants have not been vigilant about you can say that, had not been vigilant in taking necessary steps without delay. So it is no doubt true that their counsel at Champai may not have informed them about the passing of the impugned judgment and order, but at the same time, it is also the duty of the applicants to be vigilant by seeking information about the status of their case. From time to time. Full stop. The fact of the applicants having filed their written objection to the case filed by the respondents goes to show that they are aware about the pendency of the case. So even the government advocate representing them is said to have cross-examined the witnesses produced by the respondents before the learned LA judge. So therefore, solely relying upon the information to be received from their government advocate about the case demonstrates that the applicants have not been diligent while such being the position, it is also noticed that the respondents, after the passing of the judgment in order dated 29/2023, had not bothered to furnish a copy of the judgment in order to the applicants for compliance. So this can be noticed from the letter written by their counsel to the Special Land Acquisition Officer, PWD, on 24/5/2024. Which speaks for itself. So according to the submission for the learned counsel for the respondents, the said letter was written by enclosing a copy of the judgment in order before filing of the execution case, as the same was being contemplated due to non-action by the authorities concerned. The judgment in order of the trial court is 29/2023. In the letter written by their counsel to the applicants is 24/5/2024. And therefore, it is seen that a great deal of time had passed since the passing of the judgment order itself. So both the parties have cited authorities as regards the principles to be adopted while considering delay condonation. Stop. It is an established principle of law that the number of days delay ordinarily is not the relevant factor, but the explanation so tendered for the delay. And that the acceptability of such an explanation but in the present case, as already observed, the applicants have not been vigilant in pursuing the matter. And even after an information had been given by their counsel of the respondents about the disposal of the LA case, prompt action had not been taken. The apex court in Shivraj Singh and others, Supra, had considered various decisions with regard to condonation of delay, and thereafter had opined that the hidden forces that are at work in preventing an appeal by the state being presented within the prescribed period of limitation, so as not to allow a higher court to pronounce upon the legality and validity of an order of a lower court and thereby secure unholy gains, can hardly be ignored. Stop impediments in the working of the grant scheme of governmental functions have to be removed by taking a pragmatic view on balancing of the competing interests. Stop. While the, no, stop. By making such an observation, the delay condoned by the High Court in the said case was upheld. Stop. In the present case as well, while the applicants have sought to impress upon the court that the interest of justice would be defeated and that they would suffer irreparable loss, not interest of justice, interest of public. public interest uh, would suffer. And that, what did they say? The interest of the respondents, on the other hand, has also to be looked into. So therefore, upon due consideration of the case in its entirety, this court finds that despite the applicants not having pursued their case diligently, it would be for the ends of justice if the delay is condoned. Which, however, shall be subject to depositing cost of rupees 10,000 before the registry of this court within 15 days from today. So stop the amount so credited, the amount so deposited shall be credited to the account of the High Court Legal Services Committee. Of the application accordingly stands disposed of. We'll thrash it out in merits, Mr. Diagnola. Now, for the remaining two cases, give me the file.
Item 10.
The explanations are more or less same,
Yes, my lord.
isn't it?
Only the days are different.
Okay. Out here, you'll write Hard Miss Caroline K. Lung Oipui, learned government advocate. Opposite party same. And number of days delay would be
427 days.
427
27.
27.
days. And calculation of the registry is 426 days. Less. Then one citation by the Caroline is 2010.
Yes, my lord. 2010 6 SCC 786.
Are you referring to the others also, or only this?
I want to refer to the 2024 15 SCC 1, para 49, para 57, and para 58.
2024.
Yes, my lord.
Is it available here?
It was produced yesterday.
What was produced? Printed version.
No, my lord.
2024, volume 15.
Yes, my lord.
Okay. For Caroline, you'll write, council relies upon this state of UP and another versus Virendra Bahadur, Katheria and others. 2024 15 SCC 1. Then number 2, Improvement Trust Ludhiana versus Ujagar Singh and others. 2010 6 SCC 786. Only these two. I think the rest will be same. And in respect of
Item
case,
11.
Obliged.
this is item number 11. Miss
Yes, your lordship.
Lalun Louis, Government Advocate for the applicants. Number of days delay,
433 days, your lordship.
433 days delay.
Yes.
Then as per the registry, it is 433 days delay. Same, okay? Then what are you referring to?
Your lordship, I'm relying only on the one case that I produced yesterday,
Shivraj-
which is yes, your
Shivraj
lordship.
Singh. Then Reliance Place is this case. Shivraj Singh, deceased, bracket, through LRS and others, versus Union of India and another. Is it reported? It's reported. It's 2023 INSC 885. So appeal is, the delays condoned subject to deposit of that amount within
Yes,
15
your
days.
lordship. Much obliged,
In all
your
the
lordship.
cases.
Much obliged, your lordship.
Item 12 and 13.
Lordship, in this case, the respondents' council is getting married today.
Hmm?
The respondents' council is getting married today, Mr. Letsanyana.
So we should dismiss it. So we should allow it or dismiss it.
No, I have no idea about it.
You are appearing on his behalf.
No, Lordship, I am appearing on behalf of the petitioners. I'm just
Petitioners.
mentioning, yes, Lordship.
Oh, you are for the petitioner.
Yes, my lord.
But at least somebody should mention, isn't it? Somebody should have mentioned. All of them are busy. Although Miss, your good name?
Lero, pari.
Lal Ropari, learned counsel for the petitioner. Why is it listed together? 13 also?
The 12 and 13 are, Lordship, in this, we are challenging the same order.
You're for the petitioners in both.
Yes, my lord.
Now, learned counsel for the petitioners in both the cases is present. Mr. Lal Chandiana Kyangte, learned counsel for the respondent numbers 1 to 3, is absent. Stop. It is submitted at the bar that Mr. Lal Chandiana Kyangte, learned counsel, is getting married today. Stop. Such being the case, the matter is adjourned to be listed again when?
Any day, Lordship. The convenience of the court, Lordship.
After a week or 2 weeks? After 2 weeks.
Yes, my lord.
We'll list it again after 2 weeks.
Obliged.
Item 14.
May I please, your lordship. My lord, this application is for striking off under order 1 rule 10 true. Read with section 151 CPC. The main
Striking
reason,
of order 1.
no, striking
What?
of the applicant.
Striking of the applicant.
Yes, the reason being is that in the lower judgment and order, I was not given any liability anymore, and in the connected appeal, RFA 36 also, the appellant has no grievance against me. So I'm, as per my contention, I'm no longer a necessary or proper party. At this stage, my lord, my humble prayer is that let notice be issued, and if they have any objection,
Yes, Lordship, we are a bit surprised because we are the counsel for the appellant and copy is not served till date.
Okay, heard Mr. Lolbiagnu Vanamte, learned counsel for the applicant, who submits that by filing this application under order 1 rule 10 bracket 2, read with section 151 CPC, the applicant prays for striking off his name from being a party. You are at what? You are as respondent in the other
yes,
case. Respondent number
3.
as a party respondent in RFA number 36 of 2025, wherein he has been arrayed as respondent number 3.
No, Lordship, respondent number 4.
Respondent number
apologies.
4. You should have mentioned that. Respondent number 4. Anyway. Issue notice. Tunnel by 2 weeks. Miss
Laropari.
Lal Ropari, learned counsel, appears for the respondents. And accepts notice on behalf of them.
Yes, my lord. Only the appellant.
Applicant to serve requisite copies of the application within
today itself, my lord.
the course of the day. List the matter again after 2 weeks. Objections, if any, be filed by the next date.
Deeply obliged.
Deeply obliged, my lord.
Admission, item 1.
Lordship, this case maybe take a bit long, so other matters, let them take first, since they want to go out.
Can we have this matter also some other day?
When? Only to
It will take
tomorrow.
some time, perhaps. This will take some
But
time. This
Perhaps,
is the second round, isn't it?
yes, second round. Lordship, it can come to a short submission. It's not only that the way the respondent observed the petitioner is not in accordance with the judgment passed by this honorable court. So in that matter,
You have not filed contempt also, isn't it?
I have filed contempt and saying that we are settled the matter since the respondent authority that we are going to comply the order, so we withdraw the contempt. So we withdraw the contempt. Objection was made, however, in not in persons of the judgment and order passed by this honorable court.
The thing is that we'll have to consider all aspects,
Yes.
because it's not the first time, but the second round. So we have to deal with this matter meticulously. There'll be time consuming.
Right. If time permit tomorrow,
Tomorrow that another matter is fixed.
yeah, that also short matters. If possible, if not, it's okay. Nothing.
You have a date, some other day.
Next week. Next week. Let's see.
week.
Next week. Yeah.
You want a specific date?
No, let's next week, because Justice Marley also in the end of her service.
Oh.
I don't know whether
No, the reason is that if you have a fixed date, both parties can prepare.
yes,
Otherwise, it becomes very fluid. No? You may or may not.
yes.
Uncertainty is there. It's all up to you, but
4, 5, 6. 4th Feb.
Wednesday.
Wednesday is usually DB day, and
No, is it followed? Otherwise, if in other
otherwise
benches,
it follows
followed?
in other benches.
Also?
Yeah, yeah. Sometimes, sometimes it's not. So maybe Tuesday, 3rd.
yes, Ms. Lalun, do we? Okay,
Yes, Your Lordship.
Tuesday.
Yes, Your Lordship.
Okay, as agreed to by the parties, list the matter for, this is admission hearing. Admission hearing on,
Your Lordship, this is final hearing.
Yesterday, it's this week, it's a hearing list. I don't know why today they listed for admission hearing, it's a regular hearing.
you say 3rd of Feb, isn't it?
Yes,
We listed for hearing on
yes.
3rd of February 2026.
Item 2.
Lordship, in this matter, I have filed IA civil number 2 of 2026 and white order dated 27/1/2026. I was allowed for implement of
Implement of?
respondent number 7, the Secretary to the Government of India, Ministry of Environment, Forest and Climate Change. And for accepting the notice, CGC was absent. And in the last order, this honorable court had passed that the matter to be listed today, showing the name of CGC for respondent number 7 in the cost list. However, it is not listed.
But where is the amended cost title?
My lord, my clients are out of station, so we have sent them the cost title. The notary is in Guwahati.
No. Why did you send cost title to them?
Because in each of the page we have to get the seal of notary. That's why. In usual, no.
No. You have to just file the amended cost title. Are you filing a recast petition or what?
No, my lord. I have sent the amended cost title to Mr. Samuel for respondent 1 to 5 for filing before the registry, my lord. The amended cost title, we usually put the seal of the notary, and the notary we use was from Guwahati. That's why, my lord, we send it to the client for notary seal first.
So you mean to say you need some more time?
Yes, my lord. For
Filing
amending
filing
cost
the
title.
amended cost title. How
Yes.
much time?
2 weeks time, my lord.
2 weeks time. You're for the petitioners, isn't it?
Yes, my lord.
Whom did you want to implead?
S- Secretary to the Government of India, Ministry of Environment, Forest and Climate Change.
Okay, IA is already allowed.
Yeah, already allowed.
Okay. Then you write like this, Miss Bilal Nemi, is it?
Bilaram Nemi.
Bilal Ram Nemi, Learned Counsel for the petitioners, submits that although this court had allowed has allowed has directed to file the amended cause title. She requires a week's time to file the same, as the amended cause title has to be notarized from Guwahati. In view of above, list the matter again after a week,
After 2 weeks, my lord.
after 2 weeks. Ms. Zaram Sampu has no role right now, isn't it? You don't have a role right now. And so far only is the state government who is a party.
Yes, Your Lordship.
But what is this? Member, Secretary, High Powered Committee, New Delhi.
Your Lordship, this was established way back in 1990s, Your Lordship. And it was
Who
already...
appears for them?
None, my lord.
Notice has gone.
Yes. It was returned back, my lord.
Return back. Notice is complete.
Wait, where is it?
Respondent number 6.
They could not find, my lord. That's why.
See, insofar as the respondent number 6 is concerned, the last order to that effect is 24/11/25.
Yes, my lord.
Mr. Victor L. Ralte, Learned Counsel for the petitioner, is present and has prayed for 1 week time to inquire whether notice can be served upon respondent number 6 or not.
Yes. We
List,
could.
so,
And in the next order, my lord.
next order,
27
1.
1, we have submitted that
Give me the IA. IA 2 of 2026. So there's no indication about respondent number 6 thereafter.
we could not locate, that's why, my lord. Respondent number 6.
So today, what is your submission?
And in our implement application, we have
This is only for 7.
yes, my lord.
IA is only for 7. So what will happen to 6 then? What is your submission?
If I may be given more time, my
Your
lord.
Lordship, if I may intervene in this, as per the IA number 2 that was received by this office, Your Lordship, in the synopsis, it is said that the respondent number 6, the HPC, was constituted only for a specific purpose for a certain period, and that the said respondent number 6 appears to be non-existent at present. In this regard, the said HPC was indeed constituted under the Ministry of Environment and Forest Climate Change, which is a parent ministry, and the said ministry is legally responsible for action or inaction of the HPC, and hence its application.
From where?
This is the IA number 2, Your Lordship.
No,
that is-
which paragraph?
In my
Your
synopsis,
Lordship, the synopsis.
Synopsis. Synopsis in the IA.
yes, my
Yes, Your
lord.
Lordship.
So you accept,
My lord.
in your synopsis, you have written
Yes, my lord.
respondent number 6 is only is constituted only for a specific purpose. And that the said respondent number 6 appears to be non-existent at present.
Yes, my lord.
So what do you want to do?
Strike out, my lord.
Shall we? Mrs. Dinari, what do you say?
or
Lordship, actually, this case is handled by Victor, but so far as my understanding, this high power committee not existed
That's what
at
you've written.
present. So if you make a party also, it's no. So you may be allowed to give 1 week time to think about what to do it.
Okay. One more line, next para. Insofar as respondent number 6 is concerned, it is submitted. At the bar that the same is non-existent and was constituted only for a specific purpose. It is submitted, I say, no? It is submitted by Miss Lalnun Louis, learned government advocate, that the same is non-existent and it was constituted for a specific purpose. And she refers to the, in support thereof, she refers to the synopsis made, synopsis of the IA, C number 2 of 2026, which was disposed of on 27/1/2026. Stop, Ms. Dinari Tiazu, Learned Counsel, or Ms. Bilaram Nemi, Learned Counsel for the petitioner, submits that she may be given a week's time to get instructions from our clients on this issue. Next para in view of above, that the matter be listed after 2 weeks.
of pledge.
Right.
Item 3.
See?
Lordship, still Mr. Osangwala Rate, the leading counsel, he could not appear today.
You are appearing on his behalf.
Yes, Lordship.
Why? Why you can't appear today?
He has a fever and
He has a
on
fever?
sick. Yes, Lordship. So if the matter can be taken up after next week, Lordship.
Lordship, we have no objection.
No objection?
However, if interim order passed earlier may remain
Interim?
yes,
What is the interim?
for stay of the impugn order passed in IA 227.
No, paragraph 10 of the order says, having considered this court does not find any reason to stay the impugned execution of orders at this stage without hearing respondent number 5. So it was declined. There is no stay. You should check from the file, not from your phone. Mr. Osangwala Ralte, Learned Counsel for the respondent number. Okay, in the IA. Just a minute.
Yes, Lordship, there's an IA.
There's an IA.
Yes, Lordship.
Yes. The IA is disposed of what?
Not
Not
this.
No disposed.
This item number 3.
3.
IA is not listed today. It should be-
Kavir is not listed. But
No, it should have been mentioned.
yes.
It should have been mentioned. Writ petition is there, I is there. Writ petition is listed, I is not listed. And you want me to pass an order in an item which is not listed. This is the problem. See. Okay, let's rewrite again. Mr. Rosang Zol Aralte, Learned Counsel for respondent number 5, is said to be indisposed, and a prayer for adjournment has been made on his behalf. Stop. The said prayer is not opposed to by the Learned Counsel for the petitioner, but it is submitted that the interim order passed earlier should continue.
Lordship, if this matter may be listed on 12th of February.
Just a minute. Then stop. It is noticed that in the connected interlocutory application, that is IAC number 227 of 2025, this court, right, order dated
Tapos.
8/12/2025 had passed an interim order staying the impugn order dated 3/12/2025. So as such, the interim order passed earlier in the connected IA in the IA shall continue till the next date of listing. Stop. As paid for list the matter on
12th of February.
12th of, okay, 12th of
Yes,
February
yes, Lordship.
2026.
Deeply obliged.
You do one thing, you perhaps in the order sheet you can write WPC so and so with IA, okay? Yes.
Obliged.
Item 4.
Lordship, White Office Note dated 28/1/2026. Notice is deemed served to all the respondents.
Your Lordship, I'm appearing on behalf of Mr. Bilaram Enga, respondent, counsel for respondent 1 and 2. We are yet to receive a pairwise comment from MADC in order to prepare our affidavit in opposition. So if we may kindly be granted 2 weeks' time to file our ANO.
1 and 2,
Yes, Your Lordship.
not the others.
No.
Others are private respondents.
What about 3 and 3?
3 is already retired, my lord.
Huh?
He's already retired. 3 is
Retired.
already retired. Yes.
Retired.
Mm.
So what will happen? अभी नहीं उठेगा. Three
None,
is,
none has represented yet, my lord. 4 to 9.
so what do you want to do? Strike off the name or this will remain like that?
This, let him be remain.
As per office note dated 23/1/2026, AD card has returned back from respondent numbers 4 to 9. Let us see the respondent. Hmm? It doesn't have a correspondence file. Then where's the AD card then? Please rewrite the order, cancel that. As per the office note dated 28/1/2026, AD card has returned back from all the respondents, that is respondent numbers 1 to 9. Stop. As such, notice is accepted to be complete. So, Ms. B. Nalram Nemi, learned counsel for the petitioner, submits that as per the information received, the respondent number 3 has limited his office. Full stop. Then, Miss, your good name?
Sarah Lal Vensangi.
Sorry?
Sarah Lal Vensangi.
Sarah Lal Vensangi, learned counsel, submits that she is led by Mr. Bilal Ramega, learned counsel, who will be appearing for respondent numbers 1 and 2. And she prays for 2 weeks' time
Yes, Your Lordship.
to receive instructions and to file counter affidavit. In view of above, lists the matter again after 2 weeks. Respondents may file their counter affidavit in the meantime.
Yes, Your Lordship.
Item 5.
Lordship, if I may kindly be granted another 3 weeks time for filing counter affidavit, Lordship.
Similar prayer for respondent number 1.
I represent respondent number 2, 3, and 4.
Total, how many? 4 respondents.
4, yes, Lordship.
Parties are represented by the respective councils, as paid for by the learned councils for the respondents. For the, how much time?
3 weeks,
3
Lordship.
weeks' time is granted for filing counter affidavit. List again after 3 weeks.
Deeply obliged, Lordship.
Item 6.
My lord, I am for the respondent number 1 and 2. I am seeking 3 weeks time for filing my affidavit.
Your Worship, the matter involved is quite simple, Your Worship. The petitioners being aggrieved by the award passed in favor by the competent authority, they filed an application before the arbitrator appointed by the railways authorities. The arbitrator disposed of the arbitration matter, saying that there's no requirement for interference with the award passed by Kala. We've submitted an application under section 34 to the district judge. The district judge remanded the matter back to the arbitrator for re-adjudication. In the meantime, the arbitrator has withdrawn himself from the case. So this is a writ petition for a direction to the railway authorities to appoint a fresh arbitrator to substitute the previous arbitrator who has withdrawn himself from the case. And Your Worship, anyway,
Who will
since,
appoint?
the railway authorities.
Railways.
So it's quite a simple matter, Your Worship. They just have to appoint someone else to substitute the previous arbitrator.
Who was the previous arbitrator?
The previous arbitrator was Mr. Zim Moya, who was the,
Changte.
yes, Your Worship.
Lalzir Moy Changte.
He's retired now.
And arbitration case was case 1 of 2022.
Yes, Your.
So it has been remanded for fresh adjudication.
Yes,
It will be under the same number nomenclature.
yes. But a substitute arbitrator has to be appointed by the railway authorities under the provisions of the Railways Act.
Any specific provision on that? On
Yes,
that?
Your Worship.
What is that?
I'll just take your lordship to. Annexure 16, Your Worship, page 127. Page 127, Annexure 16.
Yes, which
Yeah.
part?
These are the Land Acquisition Special Railway Projects Rules 2016. And Rule 3, Your Worship, appointment of arbitrator. The central government shall, by the
No,
notification,
just a minute.
Yes.
These rules may be called land acquisition.
Special Railways Project Rules 2016.
Okay, and section?
3,
Rule
Rule 3.
Rule 3.
Yes.
Yes.
The central government shall, by the notification, appoint an officer of the rank of a gazetted officer of the state government as arbitrator for the purpose of subsection 6 of section 20F.
So any provision specifically provided for substitution,
Your Worship, that will come under the Arbitration Act,
which is
section 14 and 15.
Arbitration Act.
Yeah, para 19, Your Worship will see, kindly see para 19, page 12. Page 19, sorry, para 19.
Yes.
Section 14 and 15 of the Arbitration and Conciliation Act 1996 are reproduced below. Section 14 says that the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator, A, if he becomes de jure or de facto unable to perform his functions or for other reasons fails to act without undue delay, B, he withdraws from his office or the parties agree to the termination of his mandate. And next page, page 13, section 15 has also been reproduced.
Is it relevant? 15?
Yes, Your Honor.
Yes.
Termination of mandate and substitution of arbitrator. In addition to circumstances referred to in section 13 or section 14, the mandate of an arbitrator shall terminate where he withdraws from office for any reason.
Okay.
So Your-
Now,
since he has withdrawn himself, he even wrote a letter to the railway authorities that he is withdrawing himself.
Ms. Zainab Sangpui, it can be disposed of. It can be disposed of by giving you some time to appoint somebody. That's all. You are there for?
Respondent number 3, sir, Your Lordship.
Who's 3?
3 is
the-
Kala, competent authority.
We will be filing our Wakalnama today.
It's okay, you file, no problem.
Yeah, we took the, he was served notice by way of Dusty, and we have filed an affidavit regarding service of notice by Dusty on respondent number 3. And he has appeared today only.
We'll permit him to
Yes.
file this affidavit, I mean, file this thing. But we're disposing it of.
Your Worship, items 6, 7, and 8 are similar.
Please write hard Mr. A.R. Malhotra, learned counsel for the petitioners. Who submits that. Respondent number 3 has been served by way of Dusty and an affidavit to that effect has been filed. Top at this stage, Mr.
Daniel Frassel on behalf of Mrs. Mariel Kingte.
Daniel
Frassel.
Frassel.
Yes, Your Lordship.
Learned counsel
On behalf of Mrs.
appears on
Mary,
behalf of Mrs. Mary L. Kyangte and submits that Ms. Mary L. Kyangte, learned counsel, has instructions to appear on behalf of respondent number 3, and they will be filing their power within the course of the day.
Yes, Your Lordship.
Stop. Accordingly, notice is accepted to be complete on respondent number 3. The Ms. Ms. Mary L. Kyangte, learned counsel, to file the wakalatama during the course of the day. Stop. Next para, Ms. Zaram Sampui, learned CGC, appearing for respondent numbers
1 and 2.
1 and 2, submits that she is yet to receive instructions on the matter and therefore prays for 3 weeks' time. Stop. On the other hand, Mr. A.R. Malhotra, learned counsel for the petitioners, submits that the only issue in the instant case is in respect of appointment of a new arbitrator, since the earlier appointed arbitrator had remitted office. By superannuation from service. Stop. Considering the limited issue involved, this matter is taken up for disposal at this stage itself. Next para, brief facts essential for disposal of the writ petition is that the petitioners are landowners whose land have been acquired by award number 3 of 2019 for the purpose of execution, maintenance, management and operation of special railway project, that is Bairabi to Sairang new BG railway line project, bracket 51.38 kilometers, close bracket, in Aizawl district, Mizoram. Stop. The petitioners filed arbitration case number 1 of 2022 before the respondent number 4, which was contested by the respondent numbers 1, 2 and 3. Stop. Thereafter, the arbitrator, by common order dated 8/3/2024, had concluded that the amount of compensation fixed by the respondent number 3 does not require revision. To stop, the petitioners aggrieved filed an application under Section 34 of the Arbitration and Conciliation Act, 1996. Bracket, Arbitration Act, close bracket, and the same was registered as arbitration application number 8 of 2024 by the Court of Additional District and Session Judge, Roman 2, Aizawl. To stop, the court then white judgment and order dated 24/4/2025 remanded the matter back to respondent number 4 for proceeding afresh and to adjudicate and to re-adjudicate the matter within a period of 6 months from the date of receipt of the order. Stop. Despite the same, since the matter has not been proceeded afresh. The petitioners are before this court. Stop. In the earlier round of the arbitration, an arbitrator, namely Mr. Lal Zirmoya,
Dr. Lal Zirmoy.
Dr. Lal Zirmoy Tsangte,
Sangte.
was appointed as the arbitrator. But then he has demitted the office on account of superannuation. On superannuation, and therefore he has
31st August 2025.
on 31st 8 2025, and therefore he has expressed his inability to be the arbitrator. Bracket 6 of section 20 capital F
Of the Railways Act 1989.
of the Railways Act
1989.
1989. Stop. The earlier arbitrator was accordingly appointed under the said provision.
And if I may take your lordship to page 13, this is section 15 of the Arbitration and Conciliation Act 1996. Section 15 says that termination of mandate and substitution of arbitrator. In addition to the circumstances referred to in section 13 or section 14, the mandate of an arbitrator shall terminate where he withdraws from office for any reason, or be by pursuant to agreement of parties.
No, it's
Subclause
okay.
2.
It's
Where
okay.
the mandate of an arbitrator terminates, a substitute arbitrator shall be appointed according to the rules that were applicable to appointment of the arbitrator being replaced. So they have to appoint a fresh arbitrator according to these rules of 2016.
Okay, then continue. As per the petitioners, full stop. Mr. A.R. Malhotra, learned counsel for the petitioners, has drawn the attention to the provisions of section 14 and 15 of the Arbitration Act. Stop. Referring to section 14, bracket 1. Of the Arbitration Act, he submits that the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if within bracket small a, he becomes de jure or de facto unable to perform his functions or for other reasons fails to act without undue delay, semicolon, and within bracket small b, he withdraws from his office or the parties agree to termination of his mandate. Stop. He also draws the attention of this court to section 15, bracket 1 of the Arbitration Act, which provides for termination of mandate and substitution of arbitrator, in addition to the circumstances referred to in section 13 or section 14. Full stop. It provides that the mandate of an arbitrator shall terminate, bracket small a, where he withdraws from office or for any reason, semicolon, or bracket small b, by or pursuant to agreement of the parties.
Subclause 2 is important, Your Worship.
Stop. Further reference is made to section 15, bracket 2 of the Arbitration Act, which provides that where the mandate of an arbitrator terminates, comma, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. Stop. Next para. From the above provision, it is clear that it is for the railway authorities to act in accordance with the Arbitration Act and the rules of 2016 for appointment of a fresh arbitrator. As provided thereunder. Then what about the this thing? Railways, have they preferred any appeal or something like that
No, Your Worship.
against the judgment and order of 24/4/2025?
No, Your Worship.
So no materials, on the other hand, have been brought to the notice of this court that the respondent authorities have preferred an appeal or otherwise against the judgment and order dated 24/4/2025 passed by the Additional District and Session Judge Roman II Aizol, by which the matter was remanded back to the arbitrator for fresh adjudication. So, such being the position, the instant writ petition is disposed of by directing the respondent authorities
1 and 2, Your Worship. No.
concerned, no particularly respondent numbers 1 and appoint a fresh arbitrator in accordance with law. As expeditiously as possible. And at any rate, within the outer limit of, how much time should it take? 6 weeks?
Yes, my lord.
6 weeks from the date of receipt of a certified copy of this order.
Your Worship, for disposal of arbitration case number 1 of 2022. That was the case pending before the arbitrator.
For disposal of arbitration, case number 1 of 2022.
22.
And in the other case,
Your Worship, in the other case, the arbitration. Sorry.
1 of 2022, isn't it?
No,
That's what it
just-
said. The last one, 1 of 2022.
Yes, the last one was 1 of 2022.
And in item 7,
Item seven. That was 5 of 2022, sorry. Your Worship.
the last one.
The next one,
Next one is 5.
5 of 2022. The next one, arbitration case is 5 of 2022, before the arbitrator. Page 69 of the writ petition.
Page 69.
Arbitration case was 5 of 2023. The arbitration case will be 5 of 2023.
Apart from the number, can we, the others are same or not?
Yes, everything, same award was passed by Kala. There were different
Date?
common judgment, Your Lordship.
Okay.
This was a common judgment in all the arbitration cases. So just the arbitration case will be 5 of 2023. And Your Lordship, at page 98.
Please note that, okay?
At page 98, Your Lordship.
Item 7 will be arbitration case number 5 of 2023. The other one was 22.
Yes,
This is 23.
yes, Your Lordship. And Your
And
Lordship,
page 98.
at 8.
Yes.
The arbitration application before the district and session judge was arbitration application 6 of 24.
Yes. The date of judgment is same.
Date of judgment is same.
Okay. Okay. Arbitration case number is 5 of 23. Then arbitration application would be 6 of 2024.
Yes.
Okay. Please take note that.
And,
Remaining.
and there's another serial number 8 here.
No, remaining is same for item 7.
Yes.
Okay.
And the next case,
Item number 8. This will be arbitration case.
page 67, arbitration case 4 of 2022.
Arbitration case number 4 of 2022. Page number
67.
67.
And at page 97, the arbitration application before the district judge will be 7 of 2024, page 97.
In arbitration application 7 of 7 of 2024. Okay. Okay. I think you all can manage, no? Okay. Orders are same, only that arbitration case and arbitration application is different. And when you put up, you give me the file also. You said it's a common judgment.
Yes. The arbitration order passed by the arbitrator was a common judgment.
Common judgment.
Yes.
Let us just have a look where it's been common judgment. Oh, yes.
Starts from page 56, the first case.
Arbitration order. Annexure 15, isn't it?
No, annexure 13. Your Lordship is looking at case number
Item number 8.
8,
Item 8. Nalrin Oma.
107.
There are 1,
Page 61. Starts from page 61.
2, 3. So if you look back at the order, no, I had said, oh, case number also will differ. Anyway, we'll sort that out, no problem.
Altogether, there were 6 arbitration matters.
6. Only
Yes.
3 have come now.
Only 3 have come. The rest will come.
Okay. I had referred to one order dated 8/3/2024. somewhere in the second para or third paragraph type. Arbitration case was disposed of by order dated 8/3/24. Did I say common? Common order, that's fine, okay. So this case number also will differ. Arbitration case number so and so. That will sort it out, no problem. Okay.